Good day everyone. I am Kevin Navarro Salatsano from FC1 Main 14. Ang i-report namin ngayon is about module number 22, na kung saan ang lesson title is Recognizance and the learning target is Understand and Interpret the Silent Provisions of Republic Act 10389. Before we start, ano nga ba ang Republic Act number 10389? Ang Republic Act number 10389 is an act institutionalizing recognizance as a mode of granting the release of an indigent person in custody as an accused in criminal case and for other purposes. Ang batas na ito ay binubuo ng 12 section na kung saan ipapaliwag namin kung ano nga ba ang nilalaman ng bawat section sa batas na ito. Unahin natin ang Section 1 or short title. This act shall be known as the Recognizance Act of 2012. Ang batas na ito ay kilala bilang Recognizance Act of 2012. Ito ay naglalayong itaguyod ang pagpapalaya ng mga indigenting tao sa pamamagitan ng recognizance sa gitna ng kanilang pagiging akusado sa krimen. And Section 2 naman or Statement of Policy, binibigyan din ng batas ang pulisya ng Estado na tugunan ng mga issue ng sistema ng katarungan sa krimen tulad ng mabagal na paglilitis, kawalan ng representasyon sa batas at siksikan sa bilangguan. Kinikilala at ginagarantihan ng karapatan ng mga tao maliban sa may mga parusang kamatayan or recollection perpetua o habang buhay na pagkakabilanggo na mag-a-apply para sa recognizance bago pa man makonvict ng Regional Trial Court. Ayos na yan.
Recognizance is a mode of securing the release of any person or detention for the commission of an offense who is unable to post bail due to abject poverty. The court where the case of such person has been filed shall allow the release of the accused on recognizance as provided herein to the custody of a qualified member of the barangay, city, or municipality where the accused resides. Ayon sa Republic 10389, ang Recognizance Act of 2012, ang release on recognizance ay nangangahulugan na ang isang taong nakakulong at walang kakayahang magbayad ng piyansa ay maaaring mabigyan ng pansamantalang kalayaan sa pamamagitan ng paglagay ng kustodiya nito sa isang kwalipikadong miyembro ng isang barangay, syudad o bayan kung saan nakatira ang akusado. Maaari ding mag-apply para sa release on recognizance kung ang pagkakakulong sa krimen isinampa laban sa tao ay hihigit sa 6 na buwan. Section 4. Duty of the courts. For purposes of stability and uniformity, the courts shall use their discretion in determining whether an accused should be deemed an indigent even if the salary and property requirements are not met. The courts may also consider the capacity of the accused to support not just himself, herself, but also her family, or other people who are dependent on him for support and subsistence. Ang duty of the courts is tungkulin daw po ng mga korte na tulungan ang isang akusado at upang matiyak ang katatagan at kaayusan ng korte.
Section 5 or Release of Recognizance is a matter of right guaranteed by the Constitution. Sinasabi lang dito sa Section 5, ang paglalaya sa recognizance ng sino man na nasa kustodiya o detention dahil sa pagkakasangkot sa isang krimen ay isang karapatan. Kapag ang krimen ay hindi parusang kamatayan, recollection perpetua o habang buhay na pagkakabilanggo. Ngunit kinakailangan pa rin na ang akusado o sino mang tao para sa kanya ay magsambit ng aplikasyon para dito. Una, bago o pagkatapos makonvict ng Metropolitan Trial Court, Municipal Trial Court, Municipal Trial Court in Cities at Municipal Civil Trial Court. Bago makonvict ng Regional Trial Court, bukod dito, ang isang tao nasa kustudiya ng mahigit o katumbas ng minimum na tinakda para sa kanaming isinampa nang walang paggamit ng indeterminate sentence law o anumang kwalifikasyon ay dapat palayain sa recognizance ng tao. Dito naman sa Section 6 or requirements, sinasabi lang dito, ang karampatang hukuman ay maaaring magputos ng palayain ng isang tao o nakakulong bilang pagkilala sa isang kwalipikadong tagapag-ingat kung ang ilang mga kinakailangan ay natutugunan. Kabilang dito ang sinumpaang deklarasyon ng indigency, isang sertifikasyon mula sa Social Welfare and Development Office, arrangement at abiso sa city o municipal sanggunian. Dapat isama ng sanggunian ang paunawang korte sa agenda nito at kumilos sa kahilingan sa loob ng 10 araw. Ang aksyon ay nasa anyo ng isang resolution na inaaprubahan ng mayor at may kasamaang listahan ng inirekomendang organisasyon para sa mga tagapag-ingat. Ang namumunong opisyal ay dapat mag-submit ng resolution sa loob ng 24 hours sa mayor. At kung hindi naman ito naaprubahan, ang resolution ay kailangang ibalik sa sanggunian na punong opisyal o kalihim.
Section 7. Disqualifications for release on recognizance. Ang mga sumusunod na circumstances shall valid for the court upang i-disqualify ang isang akusado mula sa pagkuha ng mga benepisyo na ibinigay dito. A. The accused made untruthful statements in his or her own sworn affidavit prescribed under Section 5. B. The accused is a recidivist, quasi-recidivist, habitual delinquent, or has committed a crime aggravated by the circumstance or reiteration. C. The accused had been found to be previously escaped from legal confinement, evaded sentence, or has violated the conditions of bail or release on recognizance without valid justification. D. The accused has previously committed a crime while on probation, parole, or under conditional pardon. E. The personal circumstances of the accused or nature of the facts surrounding his or her own case indicate the probability of flight if released on recognizance. F. There is a great risk that the accused may commit another crime during the pendency of the case. And last, G. The accused has a pending criminal case which has the same or higher penalty to the new crime he or she being accused of. Section 8. Qualifications of the custodian of the person released on recognizance, except in the cases of children in conflict with the law as provided under RA number 9344, the custodian of the person released on recognizance must have the following qualifications. A. A person of good repute and probity. B. A resident of a barangay where the applicant resides. C. Must not be a relative of the applicant within the 4th degree of consanguinity or affinity. And last, D. Must belong to any of the following sectors and institutions: church, academe, social welfare, health sector, cause-oriented groups, charitable organizations, or organizations engaged in the rehabilitation of offenders duly accredited by the Social Welfare and Development Officer. If no person in the barangay where the applicant resides belong to any of the sectors and institutions listed under paragraph D above, the custodian of the person released on recognizance may be from the qualified residents of the city or municipality where the applicant resides.
Section 9 of RA 10389, Duty of the Custodian. The custodian shall undertake to guarantee the appearance of the accused whenever required by the court. The custodian shall be required to execute an undertaking before the court to produce the accused whenever required. The said undertaking shall be part of the application of recognizance. The court shall duly notify within a reasonable period of time the custodian whenever the presence of the accused is required A penalty of 6 months to 2 years imprisonment shall impose upon the custodian who failed to deliver or produce the accused before the court upon due notice without justifiable reason. Ang custodian ay nangangailangang mangako upang masiguro ang pagharap ng akusado sa court. Ibig sabihin niyan, kailangan o importante ang pangako ng isang custodian sa court na iharap ang akusado sa court pag kinakailangan. Kailangan kasi na maiharap ang custodian ang akusado sa tamang oras, at pag ito ay hindi natuloy o di natupad ng custodian, ang pangakong iyon maaari siyang parusahan ng 6 na buwan hanggang 2 taon na pagkakakulong. Section 10 of RA 10389, Role of the Probation Officer. Upon release of the person on recognizance to the custodian, the court shall issue an order directing the probation office concerned to monitor and evaluate the activities of such person. The probation office concerned shall submit a written report containing its findings and recommendations on activities of the person released on recognizance on a monthly basis to determine whether or not the conditions for his or her release have been complied with. The prosecution, including the private complainant, if any, shall be given a copy of such report. Sa pagpapalaya ng person on recognizance sa custodian, ang court ay mag-i-issue ng utos sa probation office na bantayan o subaybayan ang mga aktibidad ng taong iyon. Ang probation office ay kailangang magpasa ng report at ang nilalaman nun ay ang mga natuklasan na aktibidad ng taong sinusubaybayan para matukoy kung ang mga kondisyon ay sumunod o hindi. Ang prosecution kasama ang private complainant ay bibigyan ng kopya ng report.
Good day everyone, my name is Mia Parargatakyang from FC1 Main 14. Today I'm going to discuss the Section 11 and Section 12 and the Module 22, which is the recognizance. Section 11, Arrest of a person released on a recognizance. The court shall order the arrest of the accused, who shall forthwith be placed under detention due to any following circumstances. The first circumstance is, sinasabi dito sa unang statements, is if it finds materials a manifestation made under oath by any person after a summary hearing, giving the accused an opportunity to be heard. This emphasizes the importance of fair treatment and due process for the accused, even after a summary hearing based on a sworn statement. The second circumstance is if the accused feels not limited to stalking, intimidating, or otherwise vexing private complainant, prosecutor, or witnesses in the case pending against the accused, provided that upon the issuance by the court of such order, the accused shall likewise become the proper subject of a citizen's arrest pursuant to the rules of the court. Section 12. No release on recognizance after final judgment or commencement of sentence. Section 12 is typically refers to a legal provisions that prohibits the release of an individual on their own recognizance or without bail after they have been convicted and sentenced for a crime or after a sentence has begun. This means that once a person has been found guilty and their punishment has been determined or initiated, they cannot release from custody pending an appeal or the legal processes without posting bail or meeting other conditions set by the court. Despite due notice, sinasabi dito where the accused does not attend the trial or any required court appearance despite being duly notified, as outlined in Section 11 of the Arrest of a Person Released on Recognizance. This indicates that the accused has failed to fulfill their legal obligations to appear in the court without a valid reason or justification. The third circumstance is if the accused is the subject of a complainant for the omission of another offense involving moral turpitude and the public prosecutor on the mayor in the area where the offense is committed recommends the arrest to the court. The last circumstance is if it's shown the accused committed on the act of harassment such as but not limited to stalking, intimidating, or otherwise vexing private complainant, prosecutor, or witnesses